Green card sponsors at risk. Harsh new enforcement explained. What if I told you that sponsoring your own family could one day cost you thousands of dollars, even years after they've arrived in the U.S.? A new Trump-era policy shift could make that a reality for countless families. And this time, it's not just talk, it's enforcement. A quiet change with major consequences. In 2025, the U.S. immigration system is witnessing a subtle but powerful change, one that could reshape how Americans think about sponsoring loved ones for a green card. For decades, the promise behind family sponsorship seemed simple: bring your spouse, parent, or child to the U.S. and help them start a new life. But that promise now comes with strings attached: legal, financial, and deeply personal ones. The Trump administration's renewed enforcement push is breathing life into a rule that's been ignored for years: the Affidavit of Support. What was once just paperwork is now a binding financial contract with real penalties. What the Affidavit of Support really means. When a U.S. citizen or permanent resident sponsors a relative, they must sign this affidavit, a legal pledge that says, "I'll make sure my family member won't depend on government aid." Until recently, most people viewed it as a formality. Few imagined the government would ever come knocking for repayment. But now, that's changing. Under the new policy direction, immigration officials have begun warning sponsors that they will be held financially responsible if their immigrant relatives receive restricted public benefits. This isn't a new law, it's an old rule finally being enforced. And the consequences could follow sponsors for years. The shift in 2025, from symbolism to action. This year, the change is not in the legislation, but in the government's willingness to act. Federal agencies are hiring new staff, upgrading tracking systems, and coordinating across departments to locate sponsors whose relatives have received public aid. Social media posts from official immigration accounts are now directly warning sponsors will be held accountable. It's the clearest signal yet that the era of lax enforcement is over. For thousands of families, this feels like a sudden wake-up call, a reminder that the immigration system remembers every signature and every promise. Which benefits trigger liability? So, what exactly are these restricted benefits that could put sponsors at risk? Immigration authorities have highlighted several key programs that can trigger enforcement. Supplemental Security Income, SSI. Temporary assistance for needy families, TNF. State or local cash assistance programs. Long-term government-funded institutional care. Even in some states, unemployment benefits might count as restricted if the immigrant doesn't qualify under local law. The rule is simple: if the benefit gives direct financial support, it may violate the sponsor's pledge. The government sees this as a sign the sponsor hasn't upheld their financial responsibility, and repayment may follow. What benefits are still safe? The confusion, however, often lies in what doesn't trigger liability. Not every benefit is off-limits. Programs that provide indirect support, like healthcare or food assistance, are usually safe. These include Medicaid, except long-term institutional care; SNAP/food stamps; CHIP, Children's Health Insurance Program; school lunch programs; Section 8 housing in limited cases; federal student aid. These programs don't directly pay cash to immigrants, so they don't violate the affidavit. Still, families must remain cautious. What's safe today might change with a new executive policy. Real stories, real impact. Imagine this scenario: a U.S. citizen sponsors their spouse for a green card. 3 years later, the spouse loses their job and, in a moment of hardship, applies for temporary financial aid. Months later, the sponsor receives a government notice demanding repayment for those benefits, sometimes amounting to thousands of dollars. That's not fiction. That's how the new enforcement policy works. And now, officials say they intend to use these powers more often. Why it's happening now? The administration's argument is simple: accountability. They say taxpayers shouldn't bear the cost of benefits for immigrants who were supposed to be privately supported. But critics argue this approach punishes families and creates fear among immigrants already trying to follow the law. The debate reflects a broader shift in U.S. immigration philosophy, a move from compassion to strict compliance. This isn't just about forms or penalties, it's about redefining what sponsorship really means. How long the obligation lasts. Sponsors often assume their responsibility ends when the green card arrives. But that's far from true. The financial obligation lasts until one of the following occurs. The immigrant becomes a U.S. citizen. They work for at least 40 quarters, around 10 years. They permanently leave the United States. Until one of these milestones is reached, the sponsor can be held liable. That means years, sometimes a decade, of ongoing legal responsibility. Legal enforcement and financial fallout. What's different in 2025 is the seriousness of enforcement. The government now has dedicated legal teams to pursue repayment and data systems to track benefits across state and federal programs. If an immigrant receives restricted aid, a sponsor could face repayment demands, lawsuits, or wage garnishment. Immigration lawyers warn that these cases may increase dramatically in the coming months. Families are urged to keep records, communicate clearly, and get legal advice before applying for any government aid. What used to be a small mistake can now become a lasting financial burden. Communication is the key. The best protection is awareness. Families must talk, sponsors and immigrants alike, to avoid missteps. A simple misunderstanding about which programs are safe could lead to major problems. Sponsors should regularly review updates from USCIS and local benefit offices. Policy interpretations can shift without public notice. Staying informed is not optional anymore, it's essential. A new layer of pressure. Beyond the legal risks, this enforcement shift adds emotional pressure to already strained families. Sponsorship is supposed to bring loved ones together, not cause financial fear years later. Yet many sponsors now describe living with uncertainty, unsure whether a single benefit application could come back to haunt them. The system, in its current form, has made sponsorship not just an act of love, but an act of financial endurance. A broader policy picture. This crackdown isn't isolated. It's part of a wider Trump administration effort to tighten all aspects of immigration enforcement, from public charge rules to work visa reviews and green card audits. Supporters call it accountability. Critics call it intimidation. But either way, the message is clear. The era of relaxed oversight is over. As enforcement grows, some experts are warning of unintended consequences. Families may hesitate to bring relatives to the U.S. at all, fearing long-term liability. Others might avoid using even legitimate benefits, risking their health or stability. This chilling effect could widen the gap between immigrant communities and the systems designed to help them. Immigration advocates argue that the solution isn't more punishment, it's clarity, transparency, and education for both sponsors and applicants. Final thoughts. This policy shift is not about new laws, it's about new priorities. The government is signaling that sponsorship is a serious financial commitment, not a symbolic gesture. If you sign an affidavit of support, you're entering into a contract, one the government now intends to enforce. That's all we have for this bulletin. The Visa Intel USA channel provides all the essential visa information and immigration updates you need. From visitor visas like B1/B2 to work visas such as L1A. If you haven't already, subscribe to Visa Intel USA, stay informed, and stay ahead. Thanks for watching. See you in the next video.